Hello, I'm Kenneth Fernandez. I'm a professor in the Department of Social Sciences at the College of Southern Nevada, and I'd like to talk about the right to privacy. In a famous case, Gitlow versus People of New York, Justice Oliver Wendell Holmes is quoted as saying, "Every idea is an incitement," right? Especially new ideas. When the Supreme Court in 1965 ruled that there is a right to privacy protected under the Constitution, this was a very controversial issue, right? It incited much debate. And in part, this is because the notion of privacy is connected to so many different controversial things, including contraception, abortion, same-sex relations, gay marriage, right? The rights of criminals. And this right to privacy is especially controversial in part because the term privacy is never mentioned in our U.S. Constitution or the Bill of Rights. So how did this right to privacy emerge? Well, legal scholars often use the term this right was created or found through a broad interpretation of the U.S. Constitution, found by plaintiffs suing governments, right, for intruding on their privacy, bringing these cases to the Supreme Court where justices interpreting the Constitution very broadly identify a right to privacy protected by the Constitution. But this did not occur overnight or spontaneously. The right to privacy, the concept of privacy, has emerged slowly and is still developing today. So let's talk about the origins of the right to privacy. Now, as mentioned earlier, it's not mentioned in the Constitution, but the term private property is, right? So for example, Fifth Amendment, no person shall be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. This idea of private property is starting to get connected to this idea of being able to prevent people from trespassing, right, on that property. And that scholars, right, are writing about that people want private property, not just to accumulate wealth, but because they want privacy, right? So one of the early writers, one of our founding fathers, writing an article called Property, right, talks about that dominion which one man claims and exercises over the external things of the world in exclusion of every other individual. That is the definition of property. Property gives us some control over this complex world. And that property is the great fence to liberty because it is the fence to consent. We must give you consent if you're going to, right, come onto our property. Private property gives us this envelope of liberty, right? And Madison goes on to say that conscious is the most sacred of all property. So not just tangible objects like a cup or a car or a house, but these intangible concepts like conscience, right? What you think, right? So we start to expand the notion of property into other realms, right? In a case that is cited by Roe versus Wade, a case that we'll talk about in a moment, a woman is harmed on a train, severely injured by a birth falling on her head, right? She sues the train for negligence and faulty equipment, and the company wants their doctor to examine her, and she refuses, right? The Supreme Court, right, rules that to compel anyone, and especially a woman, to lay bare the body or to submit to the touch of a stranger without lawful authority is an indignity, an assault, and a trespass. We start to connect, right, our body with a form of privacy, right, that you cannot trespass on. Right? 1928 Olmstead versus United States, a defendant argues that a government wiretap on his telephone conversation is a trespass on that conversation. Now, in this case, the Supreme Court actually disagreed with the defendant and ruled that the Fourth Amendment did not prevent the wiretap on a private telephone conversation. But in a famous dissent, Justice Brandeis, right, argued that the founders conferred against the government the right to be let alone, which is the most comprehensive of rights and the right most favored by civilized men. So here, right, the right to be let alone sounds kind of like a right to privacy. And this dissent, right, and issues around privacy that reach the court often frequently have dissension among the judges because these are such controversial cases. And this dissent becomes famous because it is referenced by other judges that are looking to find a right to privacy. And we finally, in 1965, get a Supreme Court that says there is a right to privacy. Now, maybe a limited one that only protects the marital bedroom. But it's a very interesting case because it has to do with a very old law in Connecticut that barred contraception. And Griswold and Buxton and Planned Parenthood in Connecticut, they tried to challenge this law, and the first couple attempts failed, partly because one judge in one case said, look, no one has ever been arrested for over 100 years, so get out of my courtroom, right? You don't really have any legal standing. So on their third attempt to challenge this old law banning contraception, Griswold and Buxton contact local law enforcement and say, we are going to violate this statute, this very old statute, and we're going to offer birth control to a married couple, right? And the local police kind of played along and said, okay, and they went and they fined Griswold and Buxton $100 for violating this law. So now they have standing, and they can go to the court and say, look, I've been harmed by this old law, right? And we believe it's a violation of privacy and it's unconstitutional. And the courts agreed, right? They felt that this, at least a majority of judges felt that this law was a violation of a person's right to privacy. And it's the first case to clearly articulate that there is a right to privacy protected under the Constitution. Now the logic, right? Legal scholars have argued that the logic has some flaws, right? First, William Douglas argues that we deal with the right to privacy older than the Bill of Rights. Well, really, the Supreme Court is designed to really look at the law, right, precedent, previous cases, and the Constitution. So to say that we're looking back further before the Bill of Rights is somewhat problematic, right? You're saying that you're looking at something other than the Bill of Rights or the Constitution, right? But they try to articulate that this seems to be an absurd law, right? That are we going to allow the police to investigate marital bedrooms for any sign of the use of contraceptives? The very idea seems repulsive to most of us, right? And therefore, they feel obligated to sort of declare this law as unconstitutional, right? Douglas argues that although privacy is never mentioned in the Constitution, if you read it carefully, is clearly concerned about privacy because it's alluded to in the First Amendment, right? And the notion of freedom of association. And the Third Amendment, right? Barring the quartering of soldiers in your home. Or, right, unreasonable search and seizures. Or self-incrimination in the Fifth Amendment. Goldberg goes further in a concurring opinion and saying, look, the Ninth Amendment clearly states that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Right? The Ninth Amendment, he argues, says just because it's not mentioned in the Constitution doesn't mean you don't actually have that right. Now, some scholars feel that that Ninth Amendment, if used incorrectly, could imply that everything, right, that's listed in the Constitution and not listed in the Constitution is a protected right under the Constitution, and therefore governments can't intrude on those rights. That would be somewhat unworkable, and often judges are criticized for invoking the Ninth Amendment. But Goldberg does this. Right? And the Ninth Amendment does exist, right? But legal scholars are careful to say, this could be abused or misused, right? So the court is saying, look, it's never mentioned, right, the word privacy, but looking at the first, third, fourth, fifth, and the ninth, right, among others, there seems to be a clear concern for privacy. Not all justices agreed, and as mentioned earlier, right, privacy cases tend to have the most number of dissensions, right? Justice Black says, hey, I like my privacy as much as the next person, but he has to admit that the government has a right to invade it unless there's some specific provision in the Constitution that prohibits that government from taking that action, right? He's hinting, if you really care about privacy, then amend the Constitution, right? Justice Potter, he admits that this is an uncommonly silly law, which is probably why that no one had been arrested or fined for over 100 years, right? It was sort of just ignored. And he argues that we have to return to the original constitutional proposition that courts do not substitute their beliefs, right, for the judgments of elected bodies like legislatures, right? It is the elected legislatures that you and I vote for. They pass these laws. And if we don't like this law, then we tell our elected representatives, and they're going to pass a new law. That's how democracy works. And really, it's not the place of the court to replace their judgment with the elected body's judgment, right? And these are very good arguments. They're really good arguments. Even if you believe that we should have a right to privacy, these are good, solid arguments that a right to privacy doesn't currently exist, and that maybe we should put it in there if we care about it, right? So Griswold versus Connecticut, it's controversial among scholars and legal scholars because it creates this right to privacy when the word privacy is never mentioned in the Constitution. But in society and among the public, declaring that there's a right to have access to contraception in the 1960s is not very controversial because contraception is becoming more popular at that time. But about 8 years later, right, we see that this right to privacy is used in a ruling that argues that a woman has a right to have an abortion. So Justice Blackmun, right, again notes that the right to privacy is not explicitly mentioned in the Constitution, right? But we can go back, right, to previous cases that are recognizing some type of personal privacy, certain zones of privacy, right, that do exist under the Constitution. And this right to privacy, wherever it is, right, it could be in the 14th Amendment, it could be in the 9th Amendment, it could be in lots of different amendments. They're kind of admitting that you can't really find it specifically in the Constitution. But if you grab all these different pieces, right, just as we did in Griswold versus Connecticut, there seems to be a clear concern for privacy, and the court is interpreting it in such a way that this privacy is broad enough to encompass a woman's decision whether or not to terminate her pregnancy. Now, this right to privacy is then brought up in a 1986 case regarding same sex relations, where in Georgia, an individual was arrested for committing sodomy with another adult male. Right? Hardwick argues that this is a violation of their privacy and the state law should be declared unconstitutional. The court disagrees. It upholds the statute as constitutional. Right? And Justice White argues we first register our disagreement with the Court of Appeals and with the respondent that the court's prior cases have construed the Constitution to confer a right of privacy that extends to homosexual sodomy. They're not arguing that a right to privacy doesn't exist, but it doesn't extend to same-sex relations. Right? But in 2003, the court reverses itself. Right? It's a different state and a different law, but it's a similar law. And Lawrence and Garner are arrested for engaging in same-sex sexual relations. And they, as plaintiffs, take it to the courts and say, our rights are being violated, our right to privacy. And in this case, the courts agree and rule that the Texas law is unconstitutional. Right? Citing Griswold, citing Roe versus Wade, right? Liberty protects the person from unwarranted government intrusion into our dwelling or other private places, right? So it sort of connects that private property with our expectation of privacy. And these, you can see here that the concept of privacy is evolving. At one point, it is evolving to encompass marital relations, but then it's encompassing a woman's body, but not homosexual sexual relations in 1986. But then the court reverses itself and extends that zone of privacy to include same-sex relationship, right? And although the court case ruling involving gay marriage only uses the term privacy once, this notion of privacy spills into so many other issues, gay marriage, but even your cell phones, right? The data on it, the GPS location, right? That there is this safeguard of our privacy, right? In Carpenter versus United States 2018, right? The use of law enforcement of GPS location data to see if people are in the vicinity of where a crime is, right? That this location data could be used to truly violate our privacy because it provides an intimate window into a person's life, revealing not only his particular movements, but his political, religious, sexual associations. These location records, as the court argues, hold for many Americans the privacies of life, right? And that we have an expectation of privacy, and that expectation of privacy is one that society is prepared to recognize as reasonable. Right? And of course, what society considers reasonable changes over time. 200 years ago, right, the right to privacy encompassing access to birth control would not be considered reasonable. But in the 1960s, it would be, right? And in today's standards, this expectation of privacy applies to our smartphone. And again, smartphones are not mentioned in the U.S. Constitution. And so our expectation of privacy is, right, expanding and changing. Right? So courts have argued that our car does not have the same level of expectation of privacy as our home does. And law enforcement, right, has interpreted that as saying, oh, well, you know, if we can search your car without a warrant, then we can search your body, right? We could search your wallet. Oh, and you're carrying a cell phone, right? You don't have, law enforcement argued that you don't have the same level of expectation of privacy with your wallet and your cell phone. The courts disagreed. And they made the argument that in today's changing society, what we used to keep at home, our photo albums, our important documents, right? Our diary, our journal, right? We now keep on our phone. And that we do, as individuals, have an expectation of privacy for that smartphone. And you need a warrant to get that information. You need to have, right, a reasonable cause, right? Perhaps, right, you don't need a warrant to search a car, but the cell phone's different. Why? Why is it? Well, because of changing society's expectations. And of course, changing interpretations of the Constitution. And that's a good thing, because Facebook is not mentioned, or the internet's not mentioned in the Constitution. And with new technologies, facial recognition software, and all these different things, location, data, a changing interpretation may be necessary. It can be a little scary that these 9 judges on the Supreme Court are the ones that are sort of changing this document, that they're finding or creating new rights. Right? And it brings up the appropriate role of the courts. Even in Griswold versus Connecticut, Justice Douglas said, we do not sit as a super legislator to determine the wisdom need, right, of such laws regarding economic problems or business affairs. But he argues that this is different. Birth control between a couple is directly related to intimate relations. And therefore, we are allowed to act as a super legislature that imposes our will over the elected officials' will. Now, some people argue that that's problematic, right? That it's the job of voters like you and I, electing officials, to go to our state legislatures to decide these issues. And that if we care about these issues, we should elect people who care about privacy, who are going to pass laws to protect privacy, and we should amend our Constitution to include, right, provisions that protect privacy. Now, again, since the Bill of Rights has been adopted since 1791, our Constitution has only been amended 17 times. It is not an easy process, right? But we could ask our legislators in Congress or in our state legislatures to pass laws to protect our privacy if we care about those things. And perhaps it's not the role of the courts to impose, right, their judgment over elected officials. Now, the counter argument of this, right, is expressed in 1943 by Justice Jackson, who argues that the very purpose of the Bill of Rights and the Constitution is actually to withdraw certain subjects beyond the reach of majorities and officials and to establish them as legal principles to be applied by the courts. So in this argument, there are certain things that voters and legislators shouldn't touch, right? Because we are kind of aware in the history of democracy that a larger group will outvote a smaller group and say, guess what? We're going to take away your rights. Women, homosexuals, blacks, right? Or this religious minority, Mormons, Jews, what have you, right? We've seen that happen throughout history. And so the very purpose of our Constitution and Bill of Rights is to say that we don't care if 90% of people say that we want to take voting rights away from Latinos, right? We don't care that 90% of voters want that. We're not going to let that happen because it's a violation of the Constitution and the Bill of Rights. Now, where the right to privacy becomes controversial is, again, it's never mentioned in the Constitution. It's created, it's found. But perhaps we're happy that this right to privacy has been found. Maybe we're not, right? But this issue of privacy is not settled, right? Yes, Griswold seems so far away. The controversy about birth control, access to birth control, seems so far away. But this right to privacy is far from over or at an end. We've only really scratched the surface regarding this issue of the right to privacy, but I hope you found this video informative and useful.